LawSikho, waiting for instructions before taking initiative. It's like this. We have to, once the client gives you a matter or a senior gives you a matter, it should germinate in your head like a seed. That is like, where a sapling will grow. So you have to sit, think about it, think about the potential problems that can arise. There are two parts to every briefing that you get from a client or a senior. I'm assuming two or three standard scenarios: client, independent client, or a relative who has come to you, or a friend, or a parent or your parents have asked you to help out with something, okay, related to their business. All of that is one. Basically, it's a client. Okay, whether they are paying you or not is immaterial. They are a client. Another way is a senior has asked you that help me out with this in an internship, okay, in a law firm or with a litigator who got contract drafting work. Here there is one briefing that ye karna hai. This is what you got to do. And the second thing is you want to think that what the deal is and where you can add more value, where they didn't ask you to do it. Okay. The two are separate things. You want to think on both planes. Okay. Why? Because second plane is going to help in impressing them, but it takes time to think of value additions. It's not going to be super quick. So you take your time to do that, but don't mix it up. Okay. Don't add random value where it's not required. So before adding that value, you call people and say, hi, you asked me for a power of attorney, but what I see here is that ABCD also is needed and you need 3 power of attorneys here. If you have other offices, you may need more for those. You may need to draft it like this. All of that you can discuss. Okay. That's a value add. So before you do the job, you talk to them. Do you need this value add? I think this will help. Okay. So you have to take initiative directly. When you're drafting the contract, most people have a very simple conversation. Client says, I want a contract. Lawyer says, I'll charge you this much. Client will say, give me a template, or why so much, negotiate it down. Lawyer will negotiate it down in the worry of not losing the client. And then you do a mandate for dirt cheap. Later on, client realizes there's a problem. Then you have a problem that you were underpaid. So why should you work so much? All of that keeps happening. So that's a never ending circle. Could you follow the never ending circle right now? That process of taking review from the client is not going to work. So you want to actively lead the client into, okay, so this is the commercials of the deal. How are you going to make money? What is going to happen if they do this? What is your proof of delivery going to be? What quality do you need? How do you measure it? What are the objective standards to keep? What are the things that could go wrong? You will think through them also. You will ask the client also to think through them a little, so that they can identify some of the problems that'll hit them. Okay. And all this conversation will happen before drafting the contract, so that at least you have some customized framework to provide the client. No matter how many templates exist in the world, you will find yourself doing a fresh contract every time. You may not draft a whole contract from scratch, but every part of the contract that adds value, that you're getting paid for, or that you're getting acknowledgement for, is going to be things you added on your own and no other way. Then this is a very common one: not checking defined terms properly. If you don't understand the contract, what will happen is, in the big contracts, you have 10 pages of definitions, 5 pages of definitions. It's huge. And then not checking the rest of the, pages. Like if it's a 80-page contract, the remaining 70 pages, you'll not check. Are there any other capitalized terms? Do I need to define them? Sometimes the terms are not defined in the definitions clause, but you'll just say transferred property has the meaning assigned to it in clause 4 of this agreement, for example. So that process, you have to be very, very strict and rigorous. You can't afford to make a single mistake because it impacts the professionalism. Okay, so you should check all the defined terms. You should check that every time they're used in the document, they are capitalized. Why? Because if they're capitalized, they have the meaning that you have given. The defined terms are basically, literally, it's like writing a novel. Okay, you are creating a fictitious definition of a term to mean a particular thing, so that people stop referring to the General Clauses Act, people stop referring to English dictionary, people stop referring to Black's Law dictionary where you've defined a term, people stop referring to case law where you've defined a term, because you've given a specific technical meaning to the term. Let's look at the fifth point: not having a sense of mechanics and sequence. This is not sequence of the clauses, not clause 1 to 10. No. Sequence meaning, imagine the transaction flowing beginning to end. Okay. For example, you have a shareholder. I'm taking example of shareholders agreement. You can take any other also. You can take even buy and sell agreement also, like any property sale. But let's take shareholders agreement. So suppose share subscription agreement. Okay, investor is investing into the company. So one clause will say that this person will invest so much money and get so many shares issued to him or her. Okay, that's for the investor. Okay, now that's fine, that's the substance of the contract. Now when will that happen? That'll happen on a certain date. Okay, what needs to be done before that date? Okay, A, B, C, D, E, F, G, these are conditions precedent. Once these are done, then what's the confirmation that's going to go? This A, that's called like CP satisfaction. It's called a conditions precedent being satisfied. So how do you determine that? You say that the last of all the conditions are going to be satisfied, that's when this is going to happen. Then parties will meet on a particular date, do these 5 6 actions. There'll be wire transfer of the money into the bank accounts of the company. There would be issuance of shares, approval of all the resolutions at the board level, at the shareholders level, approval of the amended drafts of articles of association which are to be filed, okay, with the ROC. I'm giving you an example. Are you able to follow this with me? With me, everybody? So this mechanics, if you don't do, your contract is going to be all haywire and all over the place. Okay, because then you will not leave the right space for due diligence. Your representations, warranties will go here and there. Like as of when are they true? That will not be clear. Okay, so those problems will arise. So your mechanics, sequence, and timelines are very important. This is there in every contract. Everything that has to be done has a logistics or an operational angle to it that needs to be appropriately worded in the contract. You will not write every little thing, but you will write the broader aspect that must get completed, like all necessary approvals must be obtained. That is one way to say. Okay, then another place you will find mechanics and sequences. When you have like a right of first offer or a right of first refusal clause, you will have a notice being given by the selling shareholder to the other people to give a quote, failing which they can go and sell to outsiders. That kind of a thing is there. If that doesn't happen, then they can do something else. Okay, so that whole sequence you should be able to map out. Okay, it's almost like ABCD. If this, then this. If this, if not this, then this. Okay, that proper branch should be there. You can do it diagrammatically for your own understanding. Okay, now what this approach will help you irrespective of whether you don't know things before, and you will be able to map out when you see a new agreement. Okay, not knowing which party or firm is acting for, this is especially important if you are uh, if you are making your first contract, also if you're reviewing, because what if you are reviewing the contract in a way, even as an intern, that is strengthening the other party's position. When you're reviewing a contract, you will always let you will spot things that should be done in the other party's interest, but some things you will leave because you don't want to overprotect the other side. You want to create a balanced contract. Some parties come with the approach that our first draft will be completely one sided, favoring us, and after that we'll start the negotiation. Okay, and sometimes the mandate is that create a balanced draft. Okay, either of those cases you are not going to go out of your way to protect the other side, right? So that's how you have to review your use your contract drafting and review skills. It's like a sword. You will use the sword for a particular purpose and not for other purposes, even though you could, but you will not use it for those purposes. So you can't use it for self harm, right? That is what it is. Where were we? So not knowing what party or firm is acting for. Once I had somebody, a student, take inputs on how to review a software development or a software license agreement for a potential client, and she gave it to a relative, and the relative did it from the relative was working in a big law firm, and the relative actually reviewed it from the other side's perspective because the relative didn't have enough experience. So what you have to do as a young lawyer is know your which is the client and what how do you protect that client's interest. That happens only with prior preparation.